I want to talk a little bit about closing arguments in the beginning. You know, I have some fears sitting here before you that one of them is I don't want you to forget about my client because I've been sitting here for 2 weeks with you listening most of the time like you have and taking my own notes because as I said in my opening statement, most of this trial has nothing to do with my client. But my client is on trial, and I want you to remember that and don't lose her in the forest here of all the evidence that you've heard. The other fear I have is this is my last time. I've had a few chances to actually speak with you and present evidence in this trial. And I have a fear that you might say, well, he didn't do anything. He didn't ask any questions or put on any evidence. Well, the judge will instruct you that I don't have to put on any evidence. My client has no duty to prove anything. The burden is on the state. And that's an important burden, and that's why they get the last word. Ms. Johnson got to open this trial. She's going to get to close it. We didn't flip a coin and say, oh, she gets to go last and get the last word. The reason she gets to go last is because she has the burden of proof. She has to prove beyond a reasonable doubt that my client is guilty of the offenses she's charged with. And that's an awesome burden. That's the highest burden in our land, the highest constitutional burden. And no defendant, not DeMarquise Elkins or even my client, has any duty or offer. You know, they don't have to prove anything. One of the questions I asked at the beginning of this trial was why, you know, I want to know why my client's here. And I think to illustrate why my client's here, and what I want to talk about is maybe going into the first charge she's charged with. Because I think if you take that charge and the evidence surrounding that charge, you're going to find that it's a microcosm of this entire trial and all the state's evidence. In that count, she's charged with giving a false statement, and specifically, as alleged in the indictment. I think it's very important because the state has to prove each count, in this case, as it's alleged. The judge will instruct you on the law about that. They say that my client made a false statement and that she did provide a false alibi for DeMarquise Elkins when she reported to law enforcement that Elkins was with her during the time of the shooting death of Antonio Santiago. Now, what is a false alibi? Or what is an alibi? Well, an alibi, as a matter of law, is you know, if someone's somewhere other than where the crime's taking place, and it negates all possibility that the crime took place, that would be an alibi. So, you know, if someone says I hurt somebody and I'm clearly somewhere else, I didn't do it. Now, as far as the shooting death of Antonio Santiago, my client has a perfect alibi. That would be a good illustration. She was in jail until 10:31 in the morning of the shooting. The shooting happened at 9 o'clock or 9:15, around about there. So, if she were on trial for the murder, she would have an absolute alibi as to that charge. So, but what the state is alleging she has done is provided a false alibi for her son. Well, back to the microcosm of this whole case and why I think my client's here. On the morning of the 22nd, the day after the murder, my client is sleeping in her small efficiency apartment in her pajamas. Slamming on the door, knocking on the door. She comes to the door, and there's 7 officers with guns drawn on her. 9:30 in the morning. We had this officer up here, Investigator Oliver, and I'm sure she means well, But she was only 3 months an investigator at the time. She's leading this charge up the steps with the guns drawn on the poor woman in her pajamas. She testified that it was consensual to come in and search this lady's home, my client's home. But now she'd received some training as officer, 540 hours on getting warrants. What she testified to. Did she get a warrant, sir? That was with her get a warrant? No. All throughout this trial, we've heard about warrants being sworn out, to search various houses, arrest warrants, this thing, the other. That was never done in this case. They just charged up into her house. Now, the right to a jury trial is an important constitutional right in this country, but the Fourth Amendment is also important. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause. There's no warrant in this case as to Prima Elkins' home. None. But we heard from Investigator Oliver, 3 months as an investigator. I didn't need a warrant. I didn't need a warrant. She was acting as judge and juror. And I have a fundamental problem with that, and I hope you do too. Because all the wars, the founding of this country, and all the wars that we fought, and all the soldiers we've sent abroad, and all the defending the homeland, is for our constitutional rights. And I'm not going to have some officer who clearly didn't receive enough training come in here and tell us that she didn't need a warrant to go in that woman's house. I asked Investigator Oliver, well, did you detain my client? Was she under arrest? She said, no, she wasn't under arrest. I said, well, what's your definition of arrest? And Investigator Oliver said, well, if you feel free to leave, then you're not under arrest. Is it reasonable at 9:30 in the morning, surrounded by officers in a little 300 to 500 square foot one-room apartment, that my client felt, and they had guns out and tactical vests, SWAT vests, was it reasonable that she thought she was free to leave? And is that her choice? Is that the choice we want to have as citizens? Or, oh, there's a bunch of police officers with guns drawn on me in my house, I guess I'll just leave and let them do what they want in my house. It's not a choice. She had no choice. None. These are important issues. I mean, our society is talking about it. We saw the Boston bombing and the police going door to door, kicking in people's doors and searching their houses. The state will get up here and argue, well, they were looking for DeMarquise Elkins. Got to find DeMarquise Elkins. Well, I remind you that at that time, when they were looking for DeMarquise Elkins, he was just a suspect. And even if they thought he was in there, go get a warrant. Do it the right way. So then they're in there, surrounding my client. They're going to interview her. Do they Mirandize her? No. Not one officer Mirandized her. The judge will instruct you that if you find that she was in detention and wasn't free to leave, that she needed to be Mirandized before she was questioned, if you're to consider anything she said. She had the right to remain silent, the right to have counsel, the right to have counsel with her at all times, before and after questioning and during questioning. She had the right to be told if she said anything that it would be used against her in a court of law. Not one officer gave her any of her rights. They didn't warn her. They didn't tell her anything. And that's even the bigger key to this puzzle. They didn't even tell her why they were looking for her son. Why they were even there. So the state has charged my client. So even if you believe that, if you want to agree with Investigator Oliver that, oh, everything was hunky-dory and we followed the law and everything was done according to policy and the woman had, we don't care about her rights because we're looking for DeMarquise Elkins and we think he shot a baby. Even if you go along with that, you still have to determine, did she lie? Did she lie? Testimony I heard from the stand was that she saw her son on the 21st between 8 and 11 a.m. Then she told the investigators, well, I got out of jail that morning too. Well, then they went and they checked on that. And we heard from the detention officer, I think it's Mr. Lang, who came in here. And he said, yeah, she was in jail on a misdemeanor that morning. She got out at 10:31 a.m. There was a map, and we, at some point during the trial, I had Investigator Moore mark on there where the Glenn County Detention Center is, and it's right downtown, within walking distance of all these places. I would submit to you that there's no proof she even lied. She could have gotten out of that jail and walked over and seen her son just before 11. I mean, if she was trying to create a false alibi, would you say, oh, I saw my son between 8 and 11 yesterday. Oh, and I got out of jail yesterday. Would she tell the officers she got out of jail the day before? I mean, doesn't that go against providing some sort of false alibi? It's not a very good one, is it? This whole rush to charge the entire family on this case, and the whole rush to bypass warrants, bypass rights, and be damned, we're going to go get whoever did this, and we don't care how we get there. That's the problem with this case. I submit to you there was no false alibi. There's no proof that my client even knew about the shooting the day before. There's no proof that she had any knowledge of when the shooting occurred, even if she did know that a baby was shot the day before. So how is she charged with giving a false alibi, giving a statement that would negate the possibility that her son could have done this thing? Well, saying that you saw your son between 8 and 11 wouldn't negate the possibility of this crime at all. Not at all. I believe the law is clear that you shouldn't even consider her statements at all. That they're illegally obtained in violation of our laws, her rights were violated, and that you should just exclude any consideration. But if you don't agree with me, I implore you to look at the evidence and find that she did not lie. And she did certainly, even if she lied, she didn't create a false alibi for her son. That notion is absurd, and it was overcharged. And perhaps the overcharging and the false charging of this, specific allegation of a false alibi, perhaps the problem is that the state indicted this case within 5 days of the shooting. And let's talk about the shooting. I want to weigh in. Maybe it doesn't have too much to do with my client, but I want to give you my interpretation of what I've heard today. I think what I heard was there's 2 eyewitnesses to this event that testified before you. Ms. West, this poor woman, lost her baby, shot in the face. I mean, there's nothing more horrific than what happened to that poor woman. And then we have Dominic Lang. I lied, I lied, I lied. You got me in the lie. This guy admits to being out there to taking part in the shooting, to being a participant. And the most telling thing about it all, I guess, is if we look at, well, let's take Lang and set him aside for now. I just want to talk about West. The poor woman saw her baby shot, and she's clearly got some mental health issues going on. And she's disabled, and she lives in a small efficiency apartment, much like my client. She, was just trying to make her way. I think the evidence was clear that she didn't really exactly remember exactly where the shooting took place. There was no blood out and down the street on Ellis Street, no evidence found there. I think she just had a few, she wasn't sure, just as Dr. Kleider testified, it's hard to remember these things. But we heard from the neighbors that the police were washing blood off the corner of London and Ellis. Well, the police officers didn't tell us about that. I don't know why they didn't take pictures of that. Maybe because they wanted to conform to West's recollection of the events, which I think are largely accurate, but she was wrong exactly about where it took place. And I think that was clear from the evidence. It was probably right up on the corner of London and Ellis where she was confronted by the two individuals. But the police wanted to conform to the story and not look at the other facts. The fact that Mr. Vanderdean, who you heard through deposition, was riding his bike up Ellis Street, and he didn't see anybody run off eastward. And he didn't see anybody in the street. But he did see Miss West in some sort of confrontation. He couldn't see who she was arguing with, but she was arguing with somebody on the corner. Kind of turned. The ladies in the houses never saw anybody, but they didn't get to the window for a couple seconds. And when they did, a couple seconds later, they saw Miss West on the corner. I think the most important evidence in this case is Defense Exhibit 6. And I know you've already looked at it. And it's about, 60 photos long. The police had pulled all the juveniles that had not attended school on the day of the 21st, and they had presented that to Miss West on the day of the shooting, when her memory was fresh. And it wasn't a suggestive lineup of 6 individuals, one, like we heard. It was just a random 60 photos of all the people who had skipped school that day. And who did she pick? Dominique Lang. She said, that's him. Then we heard that she testified again in August. She doubled down again. Dominique Lang, that's the guy who looks like the shooter. That's him. And Dominique Lang says he was there. Miss West said she couldn't really identify the other boy who was there. He was ducking and hiding behind the shooter. But when presented with 60 photos, just say, do you see anybody? She picks Dominique Lang out. But then, on the 22nd, we have a lineup with a woman there to assist her. It wasn't a police officer, just some random woman's in the room, and I invite you to watch that video again. It was shown to you. Some random woman's there. She's looking at it. The police have this lineup where only one man's got a green shirt. That's DeMarquise Elkins. Some of the people don't even look like the description of the shooter. And the police are you sure this is the person? This is the person. And then she selects DeMarquise Elkins. And I'll get back to that lineup, but the whole shape of this case was altered when a crackhead named R.G. Brooks rolls up to the police, frothing and foaming at the mouth, I think is what the police officer, Juan Thorpe, said, and says, "Hey, I know the aunt of the guy who did this. But I want some money so I can get her some drugs and get her loosened up. And she'll tell me his name." R.G. Brooks lived with Deborah Obley. Deborah Obley denied it, but he lives with them. We got Dominic Lang is her nephew. Joe Lang, who admits to being in the area and wearing a red shirt on the day of the shooting, is his best friend. They hang out over there with R.G. Brooks and Deborah Obley. I don't know what they do over there, but it doesn't sound like a very good place for young men to be hanging out. But these people wanted money. They also had a problem. Dominic Lang shot this baby. They had to come up with some sort of story. They had to get him out of this. They had to do something. And the police just bit off on this idea. And it snowballs from there. It really snowballs from there. So all of that is disturbing to me. And the Brunswick Police Department's contract with the devil for $8,000 or $10,000 just kind of cements the deal that something's not right with how this case was investigated. There's something else that's not right. And it wasn't until the end of the trial that we heard from Detective Blackstock, the senior detective from the Brunswick Police Department, who came in here many, I think 22 years, 28 years on the force, and 7 years as the lead detective or whatever. And he said unequivocally during Ashley Wood's examination, "I did not investigate the baby shooting case. I had nothing to do with the baby shooting case." The problem with that is throughout the trial, we've heard many officers speaking about, "Well, I didn't make the lineup. You say it's suggestive, sir, but I just showed it to Miss West, and I just showed it to these people, and I didn't make the lineup. Someone else did that." Well, it was under Detective Blackstock's testimony that we finally heard who made the lineups used in this case. And it was Detective Blackstock, who by his own account had nothing to do with the baby shooting case. I didn't know what the description of the shooter was. So I want you to look at the lineups given to Clever Jimenez and Cullix Flores. That's State's Exhibit 157. It's a Clever Jimenez one. State's Exhibit 45 is the lineup given to Sherry West. And it's the same people. The same lineup. How could it be more suggestive? I mean, we heard from the expert that police, who are maybe all good intentions, but they want the eyewitnesses to pick someone. They say, "You can do it. I know it's hard." All these are words of encouragement. How can we have a detective who had nothing to do with the investigation of the baby murder preparing a lineup that was used with the key eyewitness, the mother of the child? And Detective Blackstock testified that he had nothing to do. He didn't know. He wasn't familiar with what the mother of the child described the shooter as being. I'll leave it to you to figure out why that was done or why he created the lineup, but it disturbs me greatly. Especially given who Miss West originally picked out. And all this other stuff, the video footage from these housing projects, what does that prove? What does it prove? And there's a still photo, I'm sure the state will point it out to you, where they've taken the split second. I mean, we all watched the videos together. They took the split second where DeMarquise Elkins breezes by Dominic Lang in one of those housing projects. I mean, he walked right by him, and they froze that pixel. And I think they're going to probably present it to you and try and say, oh well, they met and discussed how they were going to go rob someone to corroborate Dominic Lang's bizarre story. It never happened. There's no proof of any meeting between these individuals. And let's talk about that story on Dominic Lang. I mean, I don't know. But when I was a young man, I didn't walk around town and someone says, hey, you want to rob someone? I said, all right, let's go. That's crazy. It doesn't make sense because it's not true. Nothing that man said was true. Absolutely nothing. It makes a lot more sense that he would go with his best friend, Joe Lang. It makes a lot more sense that he was waiting for Joe Lang over there when he's standing around. DeMarquise Elkins breezes by, but Dominic Lang's just sitting there waiting for somebody. I don't know, but I think that we've got Miss West. I don't think she's trying to lie. I don't think she meant to lie. I think she's trying to do what's right, and I think she picked out the right person who did this crime the day it happened. That's what I think. But let's talk about the second charge my client is facing. That my client did knowingly conceal physical evidence. A .22 caliber revolver used in the shooting death of Antonio Santiago. Those of us who are parents, you don't get to pick your children. Miss West loves her children. I mean, it's really a tale of two mothers here. We've got one man, one son on trial for murder. We've got another child, a child murdered in cold blood in the street. We have two. They both love their children. We had my client already lost her son once. And she finds out he's arrested and charged with murder. I saw, Miss West, I looked over in the courtroom when her older daughter was testifying, and I saw nothing but love for her daughter, despite the fact that her daughter was up there pretty much testifying against her and implicating her in some sort of sinister plot. Parents love their children. Parents want the best for their children. What my client did was wrong to go, and there's an investigation going on. Her son is named as suspect. I don't know what her mental state was, other than probably going out and there's evidence that she went and got this gun that was under the couch, and her daughter got it and pulled it out, and then we heard it was found in the phone where they went. But that's not the issue. The allegation is that she tampered with evidence by disposing of the .22 caliber revolver used in the shooting death of Antonio Santiago. What proof do we have that the gun that she got rid of was the murder weapon? Zero. The state's case is circumstantial, yes. They believe, and they'll make their argument as to why they think DeMarquise Elkins did this crime. And they want to connect the dots. And they want to say, well, you know, he must have done it, so that must be the murder weapon. Well, the judge will instruct you that in a circumstantial case, and to be clear, the case against my client is purely circumstantial. There's no direct evidence that it is the murder weapon. The state must disprove every reasonable theory as to that gun. Every reasonable theory. Is it reasonable to say that that's not the murder weapon? Yes. It is reasonable to say that. Even if you believe DeMarquise Elkins is the shooter, why is that the gun that was used? Bullets didn't match the gun. There was 2 different kinds of bullets used in the shooting. Bullet in Sherry Westleg didn't match the bullet taken from the baby in the autopsy. The state's own expert and then Mr. Goff's expert both agreed that the gun cannot be identified or excluded as the weapon that was used to kill baby Antonio Santiago. You may not like my client. You may think that, well, if my son was charged with murder, I wouldn't be hiding his gun. But just because it was his gun doesn't make it the murder weapon. They have the burden of proof. They have to prove beyond a reasonable doubt and exclude every reasonable hypothesis of guilt. Not just prove that the gun is consistent with the murder weapon. Not just prove that the gun could have been used in the shooting. They're going to count on emotion. They want you to find, well, she needs to pay because what she did was immoral or not the right course of action. But regardless of her motives or her intent or whatever, whether it was to protect her son or what she knew, I mean, they haven't proven anything, that she knew anything other than her son was arrested on that day. Regardless of all that, they have to prove to convict her of this charge that that's the murder weapon. And they failed. The law is clear. The judge will instruct you on the law. This is the last opportunity I'm going to have to speak to you. There's going to be a lot of argument from both sides left in this case. Please don't forget about my client. Don't forget about the rights that were trampled on my client, count 1. And don't forget about what I'm saying about this gun. They have failed to prove that this is the gun. Therefore, you must acquit my client on the tampering with evidence charge. And they have failed to meet their burden as to count 1. So at the end of this trial, when it's all said and done, as it goes to Prima Elkins, I ask you to find her not guilty. Thank you.
Ladies and gentlemen, I grew up in a very small town, a town of 800 people. And my grandfather used to drive me around that town. He was a brick mason. And when I say that, I don't mean that he was a handyman or that he would occasionally brick up someone's house. He was a professional. He took pride in his work. He would drive me around. He would take me to work with him some days, and he would talk to me about how you work for a living and the type of work that you do and the expectation you should have in yourself when you do work. And he would talk about the pride he took in building those houses and making sure that everything lined up when he was bricking up someone's house, and it didn't matter if it was a very wealthy person or the poorest person. And the most important part, he said, of doing the house was not the fancy work around the edges where you have to be very ornate with your brickwork on a nice house, but it was the foundation of the house. Because if the foundation was corrupt or broken or out of line or not lined up properly or done on land that was not suited, then the rest of the house was done. It didn't matter how good everything else looked. And in this case, the state and the government and the police they were not professionals in the way they handled their investigation. And the foundation of their case in three people, Sherry West, Dominique Lane, and R.G. Brooks, is broken and cracked. You heard from Dominique Lane. He took the stand. He admitted to lie after lie after lie. 15, 16, 17 lies. He said that telling only part of the truth but not the whole truth, that doesn't count as a lie. That's a secret, Dominique Lane said. Dominique Lane became so frustrated on the stand, at one point, he finally said, okay, I lied. Now the judge is going to give you the law on how to determine the believability or the credibility of the witnesses. And you can use that. But I'm going to make a suggestion as one way to look at whether a witness is believable or not. If you believe that that witness could be left alone in the room with a wallet or a purse unattended, and that whoever owned that purse or that wallet could walk out of that room and leave the witness alone in there with it and come back in and all the money would still be in it, or that it wouldn't be taken, then you should believe that witness. If, however, you think that purse wouldn't be there, or that wallet wouldn't be there, or something would be missing, then I would suggest that you not believe that witness. Using that test, there's no question. If Dominique Lane was left in a room with a wallet or a purse unattended, it would not be there. That person got back. Next, we're going to talk about R.G. Brooks, the start of the state's case, the start of the government's case. In reality, now obviously they didn't begin with that the way they did, the way they presented their evidence, but the actual investigation began with R.G. Brooks. R.G. Brooks comes up to them, frothing at the mouth, slobbering. He says he was drunk, maybe he was high on cocaine, or maybe he just wanted to go get high on cocaine with Deborah Oblay. In either case, he comes up and he says, show me a computer. Now, he denied this. He says he never asked for a computer. But you heard from Juan Thorpe, the captain with the Brunswick Police Department, who said he asked for a computer. And he was shown a bunch of photos. And he identified a man known as Dominique Elkins. Not Dominique Lane, not DeMarquise Elkins, but another person who we've never heard from, named Dominique Elkins. And that person was locked up in the county jail, so the police knew he couldn't have done it. So what does R.G. Brooks do? He gives them some other name. Then later, they come back, another officer who you never heard from, named Top Jump, interviewed him. And they get this information about Dominique Lane and Deborah Oblay, and they go talk to them. So you have a crackhead, or a drunk, or both, who lied. And then they go find Dominique Lane, and we all know how that turned out. The third person who is the foundation of their case is Sherry West. Now you have seen a 2-hour video of Sherry West, roughly 2 hours and 15 minutes. Sherry West is a woman who was very distraught, who was very emotional, but also who acted in a rather bizarre way. You saw the video where she's laughing and cutting up with officers and making jokes with them just after her child was murdered. That's not normal behavior. You also heard from many witnesses who said that Sherry West made different identifications and somewhat inconsistent identifications about who these people were or who this person was. Someone, somebody, a man, a child, a boy wearing a red shirt and dark-colored pants with no facial hair and about 2 inches worth of hair. And you heard from Dr. Kleider about why Sherry West and those inconsistent identifications, why that's important. But that's the foundation of the state's case, those 3 witnesses. After those 3 witnesses, let's talk about the arrest and where this case ended, really, for the government. The case ended for the government on March the 22nd, for all intents and purposes, in terms of them actually looking to see and trying to find out who did it, because they made their arrest. Now, they didn't make their arrest based upon scientific evidence or video evidence, because they didn't have that yet. They didn't have any video evidence yet. What they made the arrest on was based upon the word of Archie Brooks and Dominic Lane. And then they go and arrest DeMarquis Elkins. While they're talking to Mr. Lane, they're also interviewing all these other people. They're interviewing Deborah Oblay, a woman who also admitted to lying on the stand. A woman who, by her own, well, she said she was a woman of God. Archie Brooks said you could give her a crack rock and she'll tell you whatever you want to know. She identifies someone that's not DeMarquis Elkins. Who is this person? We don't know. We'll never know who she identified. Why won't we know that? Because the police either lost the evidence or they intentionally got rid of the photo lineup. We don't know which one. Roderick Nohely would say that's important. Remember what he said? When asked about evidence, he said, every piece of evidence is important. And then when asked about the photo lineup, he backtracked, as the government's witnesses and law enforcement did throughout the case. Whenever it seemed anything could possibly go against them, they backtrack off their positions, they deny obvious facts. He said, well, if it's evidence, then yes, it's important. Well, it's a photo lineup, it's obviously evidence. Investigator Nohely's response, if it's evidence, then it's important. That's like Investigator Stroll about the .22 caliber ammunition. Well, isn't it .22 caliber ammunition that you found? No, it's .22 Magnum ammunition. What caliber is .22 Magnum? It's .22 Magnum. You heard from 2 experts about that seemingly minor point. They both said it's .22 caliber, the bullet's the same. The casing is different. That doesn't change the caliber of the bullet. A law enforcement officer would not admit that a .22 caliber bullet is a .22 caliber bullet. That is extremely strange. After they talked to Deborah Oblay, they went and they talked to Joe Lane and Diane Moran. Now you heard from Joe Lane. Joe Lane couldn't remember where he was sleeping, then he could, then the court reporter was lying in his own statement. Now what seemed to happen is that Joe Lane woke up the morning of March the 21st, sometime between 9 and 10. He was wearing a red shirt. We don't know what kind of pants he was wearing. He had to, by his own admission, walk past both London and Ellis Street, though not necessarily the intersection of London and Ellis Street, around the time the incident happened. He's a 5'7" African-American male. Right now he has about 2-inch dark hair. He has no facial hair. He's 15 years old, which is the age that Sherry West said she believed the shooter to be at the time of the incident. And when confronted about where he was that morning, he lied. He either lied on August the 1st when he testified, or he lied earlier during this trial. Now, Mr. Lang was given 15 hours. Remember, we broke at 6 p.m. We came back at 9 a.m. He was given 15 hours to answer that question. Mr. Lang had 15 hours to answer a question. The police made an arrest in this case within 25. That is a startling fact when you consider it. Joe Lang was given 15 hours to answer that question. He admits to being with Dominique Lang. He admits to being near the scene. He admits to having to walk past both of the streets. He admits to being at Hopkins' homes. Who else is at Hopkins' homes who learned from the evidence? Deborah Oblay, R.G. Brooks. The police pulled video from almost every housing project in Brunswick. Which one didn't they pull it from? Hopkins' homes. They did not pull video from Hopkins' homes, even though we know Joe Lang was there, and they talked to him on March 21st or March the 22nd, went into the early morning hours. They knew Dominique Lang was there, or he stayed there from time to time. They knew Deborah Oblay was there, and they knew the person who led them along the path, R.G. Brooks, was there too. Yet they do not pull the video from Hopkins' homes. Maybe that's because, as Investigator Blackstock told us, they don't work the weekends, and they were done after Friday. We don't know, but they didn't go pull it at any point. After they did that, after they talked to Joe, they went and talked to Diane Moran. Now, Diane Moran and Deborah Oblay say that there was this little Elkins boy, although Deborah Oblay identified the wrong person, there at some point that morning where Rena Mae Williams lives. Now, we didn't hear from Rena Mae Williams or any of the other people who were supposedly there except Diane Moran and Deborah Oblay. Diane Moran, you heard her testify. She said she gave two statements to the police. The first statement, according to both her and Officer Oliver, who interviewed her, she didn't make any mention about who this person was. No mention whatsoever. Miss Moran said, well, you know, I just wasn't thinking about it and I was in a hurry. The next time, an interview that, according to both, was still under 10 minutes, she says, oh, I knew who he was. He was Karima Elkins' son. Now, that would be odd. First, because if you have enough time to say that in a 9-minute interview versus a 6-minute interview, how does that not come out? Well, I think you got the answer from her felony conviction for aggravated assault, and more importantly, the questions that came after that. And the questions that came after that show not only did the government not do a lot of investigation in this case, they also didn't care what kind of witnesses came forward in this case. What was the question that Miss Johnson asked right after the felony conviction came out? Let's see if we can remember it together. She gets up and she says, Miss Moran, you haven't been in any trouble since you got that aggravated assault conviction. Miss Moran, well, I do have a theft by shoplifting. The next questions, I believe I asked them. Well, Miss Moran, what did you steal? I can't remember. Well, she can't remember what she's stolen because she's stolen so many things during her life. That's why she can't remember what she got convicted of. Going back to the example of truthfulness. Can a person leave a wallet or a purse unattended to Diane Moran? No. Not possible, by your own admission. And as the state showed in the way they asked that question, you haven't been in any trouble, have you? Yes, the theft by shoplifting. The government did no investigation whatsoever into the character or the decency or the honor of its witnesses. They didn't care. As long as they made a statement against DeMarquise Elkins, they could care less about what kind of person it was or what they had done or what kind of trouble they'd been in the past or whether they're going to lie or whether they're going to tell the truth. That showed in the testimony of Dominique Lang, and it showed most importantly in the testimony of Diane Moran, a witness who otherwise is not particularly significant. After they did that, the government then starts doing photo lineups. Turn on the Elmo, please. They started doing...
No, don't talk.
photo lineups like this one. And like these as well. You can see in the photo lineups, there's one person who's in a different colored shirt. You can see in the photo lineups that you have a person whose hair is completely different than anybody else's. And you can see in the photo lineups that are going to go back with you all the other differences that have been mentioned again and again and again throughout this trial. And you have to wonder why that's important to the state's case and why it matters. You heard yesterday from Dr. Kleider why that is important and why that, like Dominique Lang's testimony, is really a turning point in the state's case and proof of its broken foundation. You heard from Dr. Kleider talk about Sherry West's identification. Sherry West, a very emotional woman, a very upset woman, and a woman that has some obvious mental health issues. Miss West testified she was certain of her identification. You heard Mr. Economou stand up back there and say, "Miss West, could you point out to us in the courtroom here today who the person was?" in a very dramatic fashion. And she made an identification. As Dr. Kleider explained, there was nothing to that identification. It proved nothing. Dr. Kleider explained first that that memory doesn't work like you think it would, like a DVD player, or like rewinding a tape or a disc. It doesn't work at all like that. Your memory changes over time, like human beings change over time. It fades, it gets gray, it gets muddy. It can alter completely. What does that? First, she talked about stress. Well, if someone's holding a gun, you're going to be stressed. Next, she talked about weapon focus effect and about how someone is going to focus on the gun and not on the individual characteristics of the person. Next, she talked about something called cross-racial identification. How memory encodes and only certain things are gathered. Little bits of data here and there. Little images here and there. And she talked about how a person who is someone who's of a different race, whether it's white on black or Hispanic on black or Asian on black or black on Asian, with the one exception of African Americans on whites. That was the only exception she noted. They don't remember things as well as they would someone of their own race and someone of their own age. They can only remember bits and pieces, particularly when they're upset and they don't see them for that long of a period of time. And she said that identification, when you make an identification, you're going to become focused on that identification. You're going to become almost glued to it. And it's going to be very, very difficult for you to get away from the identification once it's made. And then she talked about the suggestiveness of identification. Now in this, we're not just going to talk about Miss West's identification, which I have up there, but also Clever Jimenez and Wilfredo Calix Flores' identification. Now, you heard about Wilfredo Calix Flores and Clever Jimenez. Not at the beginning, as it would have been done chronologically, because that incident happened on March the 11th, but at the end. Clever Jimenez and Wilfredo Calix Flores were shown these lineups. These lineups, as Dr. Kleider testified, that were suggestive because of the things I referenced, and also because of this green shirt. Remember Wilfredo Calix Flores and his testimony? He said he really couldn't remember whether he said green or not, but Detective Galdamez and Detective Blackstock, who testified yesterday, made it very clear. He remembered a green shirt. Verde, verde, verde. Green, green, green. The only person in that lineup wearing what appears to be a green shirt, the police say it's green or brown, they're not going to make a commitment on that front. The only person wearing a different colored shirt, which certainly looks like it could be a green shirt, is DeMarquis Elkins. Dr. Kleider testified about what that can mean and about what that can do. And what that can do is once a person commits to the identification, they become fixed to it. like I said earlier. They don't want to get away from it. And although human memory doesn't really work where your memory gets better over time and actually gets worse, once a person believes in their identification, they become more and more certain of it because their memory changes again and again to fix to that identification, the one they made. And she said if you have an impermissibly suggestive identification, if you have an identification that's messed up, that they can become fixed to that and not be willing to come off of it and will become more and more certain of it. And that was the testimony you heard. You heard Mr. Flores and Mr. Jimenez say, at first they weren't sure. Actually, on the forms, they marked the second block, showing that they were just essentially pretty sure, not absolutely certain. Both Mr. Flores and Mr. Jimenez did that. Yet when they testified, Mr. Flores in particular said he was certain, 100% certain. According to the science, according to Dr. Kleider, that's exactly what you would expect. The witness wants to be helpful. The witness wants to get what the police want. They want to be helpful. They want to get the person who did it. That's what Dr. Kleider testified to. What do you have from Wilfredo Felix Flores? What you have in the way he testified. He went from being not that certain to only remembering a few details to being absolutely certain about it. Mr. Jimenez went from, according to Detective Galdamez and himself, saying that all black people essentially look alike, to being able to make an identification that he was fairly certain of, to where he later became 90% certain of, to where he later became completely certain of. Dr. Kleider told you essentially that's what you would expect. Now, with Miss West's identification, it's particularly important. Because remember the video. Miss West got up there again and again and said she was certain, she was certain, she was certain of who did it. Yet, remember the video. The video, she says, I'm pretty sure that's him. I'm pretty sure that's him. And then she says, oh, hold on. Before you mark it, let me see it again. Now, she testified she never did that. She testified that she didn't do it that way on cross-examination. But according to Dr. Kleider, that's what you would expect. She wants to be helpful. She wants to solve the problem. And the police, when they told her, she said, oh, you're absolutely certain. And they told her when they said that, by the nod on the head on the video, that she got the right person. And like Dr. Kleider said, when you have that, the person's going to become fixed to their identification and not move away from it. When you look at the identification and the way the police did it, and the way the police went through their identification procedure, you see that they were suggestive. You see that it was done solely to get at Mr. Elkins. As all their investigative work and everything they did after they made the arrest on March the 22nd, that morning was. Notice, we've already talked about Hopkins Homes and how they didn't get that video. And we've also talked a little bit about Sherry West, about how she was acting odd, about her demeanor and her mannerisms, and how she laughed and how she cut up with law enforcement officers. Even after they accused her of killing her own child, she kept laughing and cutting up with them at times and threatening to sue them. Very bizarre. They never really went back to Miss West after that night and interviewed her again or tried to find out anything about her. She went the next morning right when the company opened and got a $5,000 life insurance policy. Certainly odd behavior that the police never looked into. Not only did they not look into Miss West, there was another person they didn't look into. Luis Santiago. He testified yesterday. He said that he was very compassionate to Miss West when he went to the hospital, that he touched her, that he touched her ear, that he rubbed her hair, that he touched her hand, that he was very nice and very loving. And then he didn't say anything to her right when he walked in the room about why didn't you just give them what they wanted. Now, you also heard from Reverend Culpepper, Dr. Culpepper, at the very end, the last witness you heard from. He said the exact opposite. He said when he walked in, he was told there was no physical contact between Mr. Santiago and Miss West. It's like they weren't even in a relationship. He said that he was in the room and Mr. Santiago walked in, and Mr. Santiago left right after he left. There was gunshot residue on Mr. Santiago's hands. That test result came back on April 23rd. You heard that evidence from Ms. Peppers. You also heard that in testimony from Investigator Garrett with law enforcement. Now, law enforcement said the exact opposite of Dr. Culpepper. They said that they were touching and they were holding hands and all this other stuff. It's interesting. It's particularly interesting given the nature of the reports that they did. Remember the three reports from Angela Smith and Investigator Futch and Officer Garrett? They all came back on April the 24th, 2013. They were all done on that day. All done and all evidently changed in some way the day after the gunshot residue kit came back. Yet they never went and talked to any of the non-law enforcement witnesses in the room. And the government didn't call any of the non-law enforcement witnesses who were in that room throughout their entire case. They didn't do that because the touching did not happen. Reverend Culpepper was right. There was no touching of Louis Santiago and Sherry West. The police ignored them. And there was a video. Reverend Culpepper talked about that. He went and talked to someone about maybe getting a video of it. But the police never bothered to go get a video. They never wanted to get the video because it could have led somewhere else other than DeMarquise Elkins. Just like going to Hopkins' homes could have led somewhere else other than DeMarquise Elkins. Just like asking the hard questions to Sherry West could have led somewhere else other than DeMarquise Elkins. Just like keeping the photo that Deborah Obley identified, whoever that person was, could have led somewhere else other than DeMarquise Elkins. Now, let's go further into the state's case and let's talk about two of the things they've mentioned again and again and again throughout this trial. They've shown you video after video after video. They showed you the video of two young men walking past each other, well, one walking past the other in this still photo and many still photos around that time. As Mr. McIlvaine said, it literally was boom. One step, apparently not even any conversation, no pausing. They've shown you video of Mr. Elkins walking around that morning at various places, wearing a red sweatshirt and dark pants and a silver chain. They've shown you a lot of video of that. They've made a lot of statements about a gun, this gun. They made a big show about the gun. You had Buddy Webb come here and talk about wading down in the saltwater pond to find the gun. And they called 3 witnesses about how that gun got to that pond. Let's talk about those 3 witnesses. First, let's talk about Willie Merrill. You have to like Mr. Merrill, regardless of whether you believe him or not. He says that he didn't see a gun, he didn't know there was a gun, he just heard there was a splash, and he went there to go fishing for bass in a saltwater pond that's about 2 feet deep. That's certainly an interesting way of looking at things, but that was his testimony. Then you have Ronald Elkins. Now, Ronald Elkins is a convicted felon who's not allowed to have guns, but owned a gun just or similar to this .22 caliber revolver in the past, he claims, who says that he unloaded it even though he didn't know where it came from or who had it, and he got rid of it, essentially. He gave it to somebody else. Okay? I would ask you to go back when you evaluate his testimony to that leaving a wallet or a purse in the room unattended to see whether you believe it or not. Then you have Danielle Williams, the third person, who at first, remember, she talked to Investigator Nohilly. At first she tells Investigator Nohilly nothing was left there. Nothing. Nothing was left in my apartment. I don't know what you're talking about. First story. Second story. Well, remember, Investigator Nohilly's telling her the whole time, you're a witness, you're not a suspect, you don't need to worry. Just tell me the truth. Now, Investigator Newhilly also said he lied many times throughout the course of the investigation in order to get good answers. But that's what he tells Danielle Williams. He later tells Danielle, or Danielle later tells him, okay, you know, something was left, but I really don't know what it was, and he didn't tell me he was going to leave it. Investigator Newhilly, you're a witness, not a suspect. Come on, help me out. Okay, I knew there was a gun, but I don't know where it was from or exactly how he left it. Investigator Newhilly, you're a witness, but if you become a suspect, I'm going to put you in jail. Oh, well, in that case, investigator, you know, DeMarquise left it. DeMarquise said something about it. He said he had to leave the gun here, and he left it, and I saw it. I knew exactly what it looked like now that you've shown me the gun and taught me about what it looked like. And told me that if I don't tell you what you want to hear, I'm going to get locked up. You heard similar changes in testimony from other witnesses like Dominique Lane in this case, similar to that. So you have their witness who lied again and again and again to law enforcement that the government expects you to now believe, who only when faced with being locked up tells the story that the government, that Investigator Newhilly has told her he wants to hear, and then he hears it only after she's been told by Investigator Newhilly, I'm going to lock you up. Unless I hear this, you're going to go from becoming a witness to being a suspect. And we all know what happens to suspects, right? So you have those three witnesses. You don't have any other witnesses about how the gun got there. So let's talk about this gun and the scientific evidence behind the gun. You heard from two ballistics experts. You heard from Brian Leopard, called by the state. You heard from Jay Jarvis, called by Mr. Elkins. Brian Leopard and Jay Jarvis both agree that there are hundreds of thousands of weapons that could have fired that gun, that two different types of bullets were used, one for the shooting of Sherry West and another one in the shooting of Antonio Santiago, that they never found any bullet that matched the consistency or manufacture of the bullet used for Antonio Santiago, and that there were, according to Mr. Jarvis, a conservative estimate is 1 million different types of guns that could have fired that. 1 in 1 million. He says that's a conservative estimate. There were 800,000, he says, RG pistols identical to the one the government's brought in here today. 800,000. So what sort of percentage chance is that based just upon the raw math? It's not a 1% or a 0.1% or a 0.1%. It's a 0.00001% chance that that's the weapon based upon Mr. Jarvis's conservative estimate about the gun. That is what the state spent more than a day trying to bring in. This gun, where there's a 0.00001% chance, was the firearm used based upon the math, based upon the ballistics, based upon the science. Yet, they spent so much time trying to bring it in, and the witnesses they used couldn't tell the same story more than once, or told a story like Mr. Merrill. It's just bizarre. Bizarre witnesses, felons related to the gun, bizarre witnesses, felons related to the morning of March 21st with Deborah Oblay, liars like Dominique Lane, thieves like Diane Moraine, law enforcement officers who will not commit to basic facts like a .22 caliber round is a .22 caliber round, law enforcement officers like Detective Blackstock, who says first, we don't work Saturdays and Sundays. Secondly, he says, when confronted about talking about the theory of the case in front of Clever Jimenez and shown his transcript, remember his response. Similar to Joe Lang's response, though perhaps a little more artful. He says, well, it looks like in the transcript, I said that 3 weeks ago, and I will agree that that's what the transcript says, but I'm not going to tell you definitively I talked to him about that. kind of like not saying a .22 caliber round is a .22 caliber round, or not saying that evidence was lost. It shows law enforcement officers' lack of confidence in their own case. It shows their lack of investigation. It shows their lack of planning. It shows their lack of diligence. It shows their lack of looking at things other than DeMarquis Elkins. Their lack of looking at video. Their lack of asking the hard questions of Sherry West. Their lack of asking the hard questions of Luis Santiago. The state put on all this evidence about this alibi that Luis Santiago had that he was at Walmart. You're going to be able to see the photos when you go back. 9:43 is when he walks into Walmart. The shooting happened sometime around 9:10 that morning. 9:10 to 9:15. More than enough time to get to Walmart. He said he went to TJ Maxx with all these other witnesses. Didn't hear from any of them. And even Mr. Santiago, when confronted about it, he admits he wasn't at Walmart yet. He admitted that. Now, Mr. Santiago is not a particularly trustworthy guy, as Dr. Culpepper showed. But he even admitted to being there. No hard questions were asked to Mr. Santiago about this case. A man who's a convicted felon and a convicted liar, as the convictions that were introduced against him show. They didn't want to look at that because they were not going to look at anything that was not DeMarquis Elkins. The judge, when he reads you the charge, is going to tell you this is the law about evidence. He's going to say, you would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. That's the charge the court will give you. That's the law part of it. As you can see, it's going to be a rather long reading of the law. That's that. In this case, the government, law enforcement, made no effort to look beyond the person they arrested. They made no effort to go to Hopkins' home and pull that video. They made no effort to go to the hospital and pull that video. They never asked the hard questions to Joe Lane. They never asked the hard questions to Dominique. They never talked about how Sherry West identified Dominique Lane as the murderer, as the shooter. He certainly meets the description. He's an African-American male. He's 15 years old. He's got hair that's about 2 inches or so. He's got no facial hair. And Mr. Lane, remember Miss West's original identification. Let's think back to that. A 15-year-old boy and a 5 to 6-year-old boy. The only evidence of a 5 to 6-year-old boy in this case is when Dominique Lane talked about hiding his sweat, his black hoodie. The black hoodie found behind the mattress in the yard at 1021 Martin Luther King. Questions were asked about that. He said, well, you know, that's my brother's hoodie. Questions were asked about his brother. Well, I have 2 brothers. I have one that's 10. That was the hoodie that was hidden. And I have another that was 5. The man who admitted to being at the murder scene, who was 15 years old, who matched Miss West's physical description of the suspect, has a 5-year-old brother. No evidence the 5-year-old brother was ever talked to. At all. Never looked into. Never figured out where he was. Reasonable theory. Joe Lane, red shirt, near the scene, had to walk by it. Could have gotten the video from Hopkins Homes to see what time he left. Could have seen if R.G. Brooks was there, if Deborah Oblay was there. Maybe Dominique Lane was there that morning. He lied about virtually everything else. Why not that? Never bothered to go get it. Didn't care. Didn't want to know. They already had their guy. They were only going to look at that. They were only going to look at that. They were going to pretty it up and make it look good. Not going to go to the hospital and see if the gunshot residue story that Luis Santiago, the convicted felon, the convicted liar, gave them was true or not. Why go look at that? We have our arrest. We finished it in 25 hours. We're done. We're not going to go look at it. We're not going to be professionals. We're not going to do the job we're supposed to do. We're not going to make sure our foundation's in order. We're going to go ahead, build up our house, throw the roof on it, and be done with it. They finished their case in 25 hours. Everything else they did after that, they just sugarcoated it. They just put whatever they wanted to put, left out whatever they wanted to leave out. That's why Deborah Oglay's photo lineup's not here. That's why they never talked about Dominique Lang or the identification of Dominique Lang. You have Dominique Lang. You have Joe Lang. You have Louis Santiago. You have the odd and bizarre behavior of Sherry West. None of these things ever investigated. None of these things ever looked into. But what they do have is the dead baby. They have shown a large number of photographs of the dead baby. It is horrible. It is gut-wrenching. It is truly sad, those photos. They would move the emotions of anybody. The government is unquestionably, they get the last word. They get the last say. They're going to come back up and they're going to show you those photographs. And they're going to move you again. Because any human would be moved by that. Anybody would. And they're going to say, there's a dead baby. And this guy's wearing a red shirt. And they pulled a gun out of a pond. And he's got this silver necklace on. And all these people have identified him. Let's not worry about the circumstances of the identification or the problems with the identification. Don't worry about that. We have a dead baby. That's what they're going to tell you again and again in their closing argument. Ladies and gentlemen, as jurors in this case, you have an unsavory duty. Duty that no one would want. To have to look past the dead baby and to look at the facts of the case and look at the investigation the police did and the lack of investigation after they made the arrest. You're going to have to look at that. And that's not going to be fun. It's not going to be pleasant. Just like no part of this trial has been pleasant or fun. It's going to be difficult. It's going to be hard. But ladies and gentlemen, when you look at the evidence, and you look at the way the state stopped any time something could point at someone other than DeMarquis Elkins, and you look at the character of the witnesses, and the way they're thieves and liars, and the way that police will not even admit to obvious facts, and the way the government ignored the character of its own witnesses, you will see that you have a duty to find DeMarquis Elkins not guilty. Ladies and gentlemen, thank you very much for your time and your attention throughout this case. There is no higher honor in my profession than to argue a case before a jury.
Ladies and gentlemen, we're going to take a 10-minute recess. Minutes.
Yes, sir.